2024 term that just ended. We've been very pleased with the response that we've been getting for this forum, and are so glad to see you all with us today. My name is Andy Foyce. I'm the chair of the Administrative Conference, known as ACUS. And let me take just a moment before we get started to talk about ACUS. ACUS is an independent, nonpartisan agency in the executive branch of the federal government that, as I like to say, tries to help government work better. And one of the ways we do that is to provide a forum where federal agencies and other experts can collaborate to study, exchange information, and recommend improvements to federal administrative procedure. The ACUS Assembly consists of representatives from 50 federal agencies and dozens of scholars, experts, legal practitioners. That body actually adopts the formal recommendations for action by agencies, the President, the Congress, and the judiciary. We also hold and commission independent research reports. We publish research and reference guides and organize events just like this one. This forum has been an opportunity to hear from many of our experts and others as they discuss the significance of those four cases, and especially the effect that they will have on administrative agencies, procedures, and processes. In the first two panels on Tuesday, experts from our conference discussed Loper Bright and then the Jarkissi case. We hope that those of you who are able to join us at those benefited from them. If you missed them, they've been recorded and will be easily viewable at a future time. Today, we turn to the Corner Post Incorporated versus Board of Governors of the Federal Reserve System case. And I'll end with sincere thank yous to everyone involved, the moderator for our panel, the panelists, and ACUS staff, all of whom have worked very hard on bringing this panel to you today. So let me turn to our moderator, Elizabeth Papez, who is a public member of ACUS and also a partner at Gibson, Dunn, and Crutcher. Elizabeth, thank you for doing this for us, and I'll turn it over to you.
Thanks, Andy. It's my pleasure. Thanks to you and all of and everyone at ACUS for hosting these fora. I think it's a timely and exciting set of discussions we're having on this panel in particular, and it's my great pleasure to introduce our four panelists today. I'm going to provide brief introductions and then I think turn it over to Jonathan Siegel to kick off our panel discussion. I think we'll have some time at the end, hopefully, to collect questions from the chat. So look forward to hearing from all of you who are in the audience today. Our first panelist is Jonathan Siegel. He's a professor at the GW Law School, an administrative law expert. He joined the faculty in 1995, following 4 years as a member of the civil appellate staff at the Justice Department, where he, of course, briefed and argued appellate cases on behalf of the president and numerous government officials and executive branch agencies. He is also a former law clerk at the DC Circuit, has written widely on administrative law topics, and is a graduate of both Harvard and Yale. Our second panelist today is Allison Zieve, the Director of Public Citizens Litigation Group. She is also an administrative law expert whose practice addresses a wide variety of administrative law issues, including in public health, consumer and financial protection, open government, federal preemption, and First Amendment issues. She has extensive experience as well handling matters with federal agencies and arguing before federal courts, including the United States Supreme Court. She is a senior member of ACUS and has taught as an adjunct professor at Yale, Georgetown, AU, and elsewhere. Our third panelist today, I'm pleased to welcome my former colleague at the Justice Department, Aditya Bamzai. He's a professor at the University of Virginia Law School, also an administrative law expert who's working with our last panelist, Professor Duffy, also at UVA, on an ACUS project about the limitations periods we're going to be discussing today. That project predated the Corner Post decision and is progressing in light of the decision. So some interesting work there. Professor Bamzai has extensive experience both as a litigator on administrative law issues and also in the executive branch. in the Office of Legal Counsel, National Security Division, and also as a member of the Privacy and Civil Liberties Oversight Board, the federal agency charged with balancing national security efforts with the need to protect privacy and civil liberties. So great perspective. And last but certainly not least, Professor Duffy also of UVA Law School, who has a great wealth of work and knowledge on administrative law, but also intellectual property law, where he is one of the most influential scholars in the nation. And he's been working on this project for ACUS and has experience in the private sector as well as the government. Very excited to welcome you all. Professor Siegel, do you want to kick it off a little bit with some discussion of the decision itself? Because it's not clear to me everyone's had the chance to read it. It's quite long, 6-3 Justice Barrett, with Justice Jackson saying in the dissent that this could open the door to a tsunami of lawsuits. Welcome your comments on how we should be thinking about this decision before we start discussing what goes forward.
Sure. So I presume most people attending this forum are familiar with the case, but let's just take a couple of minutes to set up the issue. So this case arose in the context of interchange fees. These are the fees that a merchant that accepts a debit card as a form of payment has to pay to the bank that issued the debit card. So for economic reasons, these fees got to be too high. And in 2010, Congress passed a statute directing the Federal Reserve Board to issue a regulation limiting these fees. And the board did that in 2011. And at the time, some merchant groups were unhappy. They thought the regulation wasn't strict enough. So they brought a lawsuit. They challenged the regulation. They said the statute requires the limit on these fees to be lower than the limit imposed by the regulation. And that challenge went to the DC Circuit, and the merchants lost. The regulation was upheld. Okay, so now some time goes by, several years, in fact. And in 2021, another merchant group decided to try again in a different circuit. So a merchant group brought a similar challenge to the regulation in a district court in the 8th Circuit. And this time the government said, wait a minute, you're suing the United States. You're subject to the limitations period of 28 U.S. Code 2401, which says if you want to sue the United States, you have to do it within 6 years. This regulation was now promulgated 10 years ago. So you're out of time. The case has to be dismissed. And the merchant groups, sensing that the government had a point, they ran out and recruited a new plaintiff. And that plaintiff was Corner Post. And Corner Post was another merchant upset about interchange fees. But the key thing about Corner Post was it didn't even exist in 2011 when this regulation was promulgated. It wasn't incorporated until 2017, and it didn't start doing business until 2018. So Corner Post said, we didn't wait 6 years, so our challenge is timely. And the district court and the 8th Circuit said, no, dismissed. You have to sue within 6 years. The regulation is 10 years old, dismissed. But the Supreme Court granted certiorari. So the case goes up to the Supreme Court, and the question is, when a plaintiff brings a facial challenge to an agency regulation, and that challenge is subject to the limitations period of Section 2401, so it has to be brought within 6 years, within 6 years of what? Does the plaintiff have to sue within 6 years of the time the agency promulgates the regulation? Or do they have 6 years from the time the regulation injures the particular plaintiff involved? That's the question. And the Supreme Court, speaking through Justice Barrett, said, this is very straightforward. The statute says you have 6 years from the time the right of action first accrues. And we all know a right of action accrues when you can sue on it. Right of action can't accrue before you can sue on it. So the time runs from the time the regulation injures the particular plaintiff. So this suit is timely. And the dissent by Justice Jackson said, no, that's wrong. You have to read the statute in context. It's true that the phrase when a cause of action accrues often means the time that the plaintiff can sue on that cause of action. But here, the particular context is suits challenging agency regulations on their face. And in that precise context, it's always been understood that the time runs from the time the agency promulgates the regulation. So reading the time limit in context, this suit is untimely. And moreover, the dissent said, this is going to have very serious negative policy consequences because it means that there will be endless suits. There will in effect be no time limit on the time to challenge an agency regulation. So no matter how long a regulation has been around, maybe 50 years, it can still be challenged. And particularly when you combine that with other cases from this term, such as Loper-Bright, which make the challenges more likely to succeed, this is going to have very destabilizing consequences. So that's the issue we're here to discuss. It's a clash between what purports to be a very simple, straightforward reading of statutory text and a reading that purports to be more nuanced and contextualized, and that also purports to avoid what are said to be very serious negative policy consequences of the majority reading. That's what we'll be discussing.
Thank you so much for that. That was extremely helpful. And what I think will be great is we'll go maybe round robin. So each of you has a chance to offer some preliminary comments just to roadmap a little bit for those listening, and then maybe get into some interactive discussion, because I think all of your perspectives will be great as we start to think about what comes next. And on that subject, Allison, would you like to comment on what now, particularly from your seat as someone who deals with a lot of this agency litigation every day? Would welcome your thoughts.
So first, I think it's important to recognize that the decision does not apply to every challenge to every agency action. There are a large number of statutes that specify that an agency action has to be challenged. Any challenge has to be brought within 60 days of the agency's action itself. So those statutes are clearly both a statute of limitations and a statute of repose. You know, at 61 days, you're out of luck. Those statutes are both have a sort of statute of limitations, but they're also written in a different way. So the textual analysis that Justice Barrett was leaning on and Justice Jackson was disagreeing with doesn't apply to those cases. And I think that that all 9 justices would agree with that. There are some examples in the opinion, but there's really a lot of examples. There's also some examples in the SG's brief. So for instance, if you work in the environmental area, a ton of the potential challenges would not be impacted by Loper-Bright. If you're more interested in cases involving the CFPB or the FDA, a ton of challenges. I just said Loper-Bright, but I meant Corner Post. They are merged in my brain, as I will explain. But a lot of challenges to FDA actions, various other parts of HHS, CFPB, a lot of statutes do use the 6-year statute of limitations, which I would say is now no statute of limitations at all. As Corner Post shows, there's always a new store that's opening up, a new trade group that's opening up, a new nonprofit representing relevant interests that's opening up, a new person that just reached the age of majority, a person who just graduated from medical school or some other professional school, just entered an industry where some regulation affects them. So I think that Justice Jackson's observation that this is sort of removing any statute of limitations at all for those agency actions that were subject to 2401 is correct. The reason I get this case in Loper-Bright, I don't get them confused, but in my head they're of a piece, is because of I think many of you probably listened to the Loper-Bright ACUS discussion 2 days ago. One of the things the chief says in Loper-Bright is that the overruling of Chevron does not affect the stare decisis weight of prior decisions. I think that Corner Post has a lot to say about that. It's true a decision is still a decision today, even after Loper Bright that relied on Chevron. That's still good law, those cases today. But the Corner Post decision means that cases that the government won in the past because the court used Chevron deference, you find a new plaintiff and you can try a new challenge, and the court, the government won't get deference in the new case. I don't want to go into it, but I think the Brand X decision of the Supreme Court also has something to say about whether you could even bring those cases in the same circuit that had previously upheld a regulation. But at a minimum, you could go to a different court in a different circuit. The 60-day statute of limitations for various agency actions, those almost always say to bring the case in a court of appeals, and often channel the cases to a single court of appeals. That's not true for the ones where the 6-year statute of limitations from 2401 applies. Those are cases that are going to be filed in a district court, which means there are a few hundred options for plaintiffs and 12 different or 13 circuits that might ultimately weigh in. So that was true before these recent decisions, and it's true today. But the difference now is that instead of having up to 6 years, which is already a long time, to bring several cases in several district courts, there's now really an infinite amount of time. And I know that there are people, both the industry side or anti-regulatory side, pro-regulatory, anti-regulatory, that are looking back at older regulations to see whether they might have a better shot than they had in the past. I'll stop there.
Thank you so much. I think we're going to be coming back to some of these points, obviously more discreetly as we kind of get into the conversation, but why don't I turn it now to Aditya? I don't know if you want to talk a little bit. Kazia has placed in the chat, for those of you on the webinar, a link to the ACUS project you've been working on with Professor Duffy. I defer to you how much you want to touch on that or just offer some comments picking up on where Allison left off about what this decision may mean going forward, both insofar as the universe of cases that it does affect. And then also, and I think we've had a little bit of discussion about this privately, how does this intersect not just with Loper Bright and the deference issue, but also with the types of relief one can seek in one of these actions, if you'd like to pick up there.
Well, thanks so much. Thanks to John and Allison for setting out this framework for understanding Corner Post, and thanks to Elizabeth for the introduction. I thought what I would talk about, Elizabeth, is trying to provide a little bit of background on how we got to Corner Post, because I think that how we got there actually helps people understand just why the court had these two different perspectives and where the justices were coming from. And if we have time, Elizabeth, maybe you can return to me and I can try to highlight some of the nuances from the opinion that I think will be relevant to future developments in the law and maybe future litigation or things that people have to think about. All right, so first, how we got here. When Congress passed the Administrative Procedure Act in 1946, it did not establish a general statute of limitations or a statute of repose for APA claims. The statute just doesn't include a statute of limitations. That's why when we're talking about the particular statute of limitations at stake in Corner Post, it's 28 USC, not 5 USC. It's another statute of limitations from elsewhere. In fact, the absence of such a provision prompted Attorney General Tom Clark, who was later Justice of the Supreme Court, when he issued the Attorney General's Manual on Administrative Procedure in 1947, 1 year after the Act's passage, to remark that, this is a quote, "The time within which review must be sought will be governed, as in the past, by relevant statutory provisions or by judicial application of the doctrine of laches." And the relevant statutory provisions, I assume what he was referring to, there's actually a citation in the report, are the types of organic statutory provisions that Allison was referring to, particular provisions that might trigger a challenge within a certain amount of time. And then the doctrine of laches is the principle in equity that equity will not aid a plaintiff whose unexcused delay, if the suit were allowed, would be prejudicial to the defendant. And what's interesting is that here we have a report written in 1947, and the Attorney General does not cite 28 U.S.C. 2401A, which is the provision that everyone in Corner Post agrees is the applicable statute of limitations. And the question to why, the answer to why he's not citing that provision is a little bit complicated. But the gist of it is that Section 2401A originates in statutes that create the Court of Claims. And then after the passage in 1887 of the Tucker Act and a recodification of the code in 1911, the predecessor version of 2401A applies solely to claims under the Little Tucker Act. And when Attorney General Clark is looking at the U.S. Code in 1946, he wouldn't have looked at that provision, which applied to the Little Tucker Act, as the provision that supplied the relevant limitations period for APA claims. It just didn't read that way. But in 1948, Congress recodifies Title 28 of the U.S. Code, which is where you can find Section 2401A, and Congress drops the language from that provision that would have made Section 2401A applicable solely to the Little Tucker Act, and it seems to convert the provision into some sort of catch-all limitations period. And as a result of those 1948 edits, the provision reads, still to this day, that every civil action commenced against the United States shall be barred unless the complaint is filed within 6 years after the right of action first accrues. So as a result of those 1948 changes, many courts of appeals begin to describe Section 2401A as providing a catch-all limit for non-tort actions against the United States. And notice, of course, as John pointed out, that the language seems to run from the time a right of action first accrues. And that's similar to how Congress during this era had defined the limitations period for other administrative claims, like in the case of the Interstate Commerce Act or the Railway Labor Act in the 1930s. But it's different from how Congress sometimes established a limitations period, such as, for example, in the Emergency Price Control Act of 1942. And that required a claim to be brought within a period of 60 days after the issuance of any regulation or order. So that's very clearly the trigger is the issuance of the regulation or order. And that's a little bit different from a provision that says when the right of action first accrues, which is actually just the dispute that occurs in Corner Post. There's one other little quirk that explains how we got here, and that is that even though Section 2401A was described as a catch-all, it still wasn't obviously applicable to APA claims because the statute applies on its face to claims, quote, against the United States. And before the waiver of sovereign immunity added to the APA in 1976, actions under the APA wouldn't naturally have been understood to be against the United States. They would have been brought against agency officials. So even after the 1948 codification, and before the 1976 waiver of sovereign immunity, it's quite likely that people did not think of this statutory provision as being applicable to APA claims. What's the takeaway of this complex history? It seems to me, number one, that the way in which Section 2401A becomes applicable to APA claims is something of an accident of history. It's not clear to me, though I'm happy to be corrected if people know of specific instances when members of Congress, it's just not clear to me members of Congress really sat down at some point and said, 2401A applies to APA claims, and here's how, and here's what accrual means. Instead, we sort of backed into having 2401A be the default statute of limitations, and we backed into APA claims being thought as against the United States. So these were statutory amendments that really Congress was thinking about other things, waiving sovereign immunity, recodifying the code, and they ultimately lead to 2401A being this backdrop statute, unless there's a provision in the organic statute that applies. And it perhaps also this history explains why it took until 2024 for the court to address this question. It seems like a very basic question. Why didn't we have an opinion from like the 1950s to tell you what the statute of limitations is for APA claims? It just wouldn't have been natural. Like that would not have come up because Attorney General Tom Clark, they wouldn't have thought of 2401A as providing the relevant limitations period. So I think that helps explain, why it took some decades for this to all play out. And then finally, I think it explains the positions that these various justices are taking in the corner post litigation. In a nutshell, the majority's position, if we just paint with a very broad brush, is that the term accrues in 2401A, when applied to APA claims, just means the same thing. It means in all other kinds of statutes, in the private law context, when we're talking about constitutional challenges to statutes, non-administrative actions, this is the same thing. It's the same word. And I think there's some force to that because it is in fact the same word, and we just backed into using it in this context. By contrast, the dissent is saying, well, in general, when Congress establishes a limitations period for challenges to rulemaking, they do establish that limitations period from issuance or entry of a regulation or relevant order. And so we should understand the accrual language in 2401A against that backdrop. So I think that's the way in which we got to the corner post litigation and why it's a little bit relevant to how the corner post litigation plays out and maybe why we're asking this question in 2024, decades after the APA is enacted. And then I'll just flag the 4 issues that I was thinking of talking about, which we can talk about when we open up the discussion. The first is obviously corner post now raises the question of what is accrual? And so that's something that's worth thinking about. Second, there's interesting language in the corner post litigation opinion, on the nature of procedural claims under the APA. So I'll be happy to talk about that. Third, I think Justice Kavanaugh's opinion highlights this, but there's a series of questions one could ask about the relationship between the timing provisions, either of 2401A or other provisions, and the issue of what's come to be known as universal vacatur of rules under the APA. And then fourth, I think, just stepping back, I find it useful to think about how the corner post litigation was about affirmative APA claims against the government. It's important to understand that challenges to rules, absent some sort of specific provision that was applicable, such as, for example, the Hobbs Act, challenges to rules could have occurred in enforcement actions, just in general. And so it might be worth just thinking about how those two relate to one another. But I'll stop right there for now.
Thank you so much. I want to make sure we get to, certainly last and not least, Professor Duffy, some comments. I will say, picking up on where you were, Aditya, I mean, I think the opinion acknowledges the ball may be in Congress's court. That's certainly consonant with some of the comments in the history you've given. But I don't know, John, if you want to comment on that or some of the other forward-looking issues before we circle back to some of the points that Aditya just mentioned before.
Yes, I think one of the things that Aditya and I are doing in trying to bring this ACUS project to completion, now that there's been this big Supreme Court decision, is to think about what possible legislative options are. Aditya gave the history. I will say, I know we have a lot of practitioners in the government, or at least a lot of people registered for this for the government, and there's other people who might be challenging government action. One thing to do, and this is recapping some of the things, is make sure that this statute is the correct statute that is applicable to whatever case or whatever action you're doing. There are a lot of statutes, including the Hobbs Act, that operate as statutes of repose, which do run from the time of agency action and then cut off review. Those are often very short periods of statutes of repose. Of 60 days is quite common. The other thing to remember, another potential period of limitations is latches, is still, I think, is still out there. If the action, first of all, is not subject to the APA, and there are some cases that fall outside the APA, most importantly, cases that involve suing the President of the United States. If you're suing the President of the United States, the President is not an agency under the APA. and therefore would and quite arguably then might just not also be the United States. That's an issue, but it may be that latches governs that rather than this statute, although it's possible that this statute governs it as well. Aditya mentioned enforcement review, and I think that any attempt to legislate in this area has to take kind of a holistic approach to figuring out what the right solution is. And in fact, the report that Aditya and I are working on really has two halves. One the first half does involve short statutes are proposed, like the Hobbs Act, that are these 60-day provisions. The lower courts have been quite confused about once that time runs, exactly what kinds of defenses can be raised in enforcement actions, and what's the meaning of the running of that statute for purposes of judicial review in subsequent cases. The Supreme Court has commented on that sometimes, but hasn't really clearly resolved that issue. Another way in which you could get judicial review, and this is mentioned in Corner Post and in the oral arguments too, about that you can seek to file a petition for rulemaking if you think there's something wrong with the current rulemaking. And the agency, that is expressly authorized in the APA, you can file such a petition. The agency doesn't necessarily, could take a long time to respond to it. And there is some judicial review, but the judicial review might be a little bit more deferential. That's an issue that's up in the air. If there is a sort of global solution to this issue about judicial review and the timing of judicial review, people might want to think about what's the right stance for judicial review, where there's a petition for rulemaking outside whatever period of limitations there is. There's also not just there are two classes currently who are really helped by this decision and might be impacted by a shorter statute of limitations. There's beneficiaries of regulation, and that's really Corner Post. Corner Post is a beneficiary. They're not being directly regulated. So if they were told you don't get judicial review until there's an enforcement action, they wouldn't get their day in court, except possibly by filing a petition for rulemaking for repeal of the rule or modification of the rule, but they would never be enforced. It's the agency was just enforcing rules against the banks. The retail parties who are affected by these, they wouldn't get their day in court in this. The other thing is that people, not just beneficiaries, but some parties are indirectly harmed by regulation. So, for example, you could imagine that the government regulates one party, but that raises prices on other parties. Those people also won't have enforcement actions against them, but they might be upset about some of the old regulations. So currently, there was very, very quickly, obviously within a few weeks, because it's available now, there was legislation introduced in the Congress by two Democratic members of the House of Representatives, and that legislation is a single section. It's a quarter page in length, and it says simply, except as otherwise expressly provided by law, an action under this section, and it's an amendment to Section 702 of the APA, under this section shall be commenced within 6 years after the date on which the relevant agency action was finalized. So that's an addition to try to sort of add in an explicit statutory a period of repose, a 6-year period of repose. I think this is just a sort of opening bargain. I don't think anybody it's just designed to sort of reproduce the result that the dissent would have had. I think if there is legislation, ultimately it's going to be somewhat more nuanced than this piece of legislation. And I think that's part of the discussion that we should open up now. Thank you.
For sure. Thank you for that. I will say, listening to this, in a simple way, I think of this decision as it decided one thing. There are many things it did not decide. And I sort of bucketize that into sort of after Corner Post, who can challenge these regulations? When can they challenge them? And what can they get? I'm going to start with the who, because I think some of you have touched on this issue. I think the court expressly reserved the question, even under its injury analysis, whether an entity like Corner Post that did not exist or was not around when the rule was promulgated, can that entity raise a procedural challenge to the rule, a deficiency like the agency didn't issue a sufficient notice of rulemaking? Because I think the court expressly reserved that question. There are people, as you just pointed out, who can't say I was there, I was hurt, I was part of the process. Does anyone think that that's a material limitation? I'm happy also to have maybe Allison start with that. I know you mentioned that there's a lot of scope here, but there's some potential limiting factors.
So I've been struggling to figure out how that's a limiting factor. So if the question under Corner Post is when your claim accrued, when were you first injured? Well, Corner Post was first injured when it came into existence in, I can't remember, maybe Jonathan remembers, was it 2019, 2018, something like that?
It was incorporated in 2017 and started doing business in 2018.
So it wasn't injured till 2018. So its cause of action accrues then. Now, of course, the section of the APA that allows challenges to agency rules that were issued without procedure required by law, that procedure, they weren't around to be harmed by that lack of procedure. So maybe they can sue, maybe I think the theory in the decision, which isn't really fleshed out very much, is maybe they can't sue for notice and comment type violation because they wouldn't have been the beneficiary of it anyway, since they didn't exist in 2010 when the NPRM went out. But on the other hand, if you're injured by the rule, your cause of action, whatever cause of action you have, stems from the time of your injury, according to the majority. And if that was 4 years ago, then I don't think that issue necessarily means you can't sue for any violation of the rule, because what injures you is the rule. So you're not claiming that I have a procedural injury or substantive injury. You're saying I'm injured by the rule. The court has already said if you have a purely procedural injury, you don't have standing anyway. So if you have standing, you're injured by the rule, and I don't know why you couldn't sue to challenge any aspect of the rule or rulemaking you didn't like.
I'd welcome
maybe
others.
not for the notice and comment violation.
I'd welcome views on that, and also if others have thoughts on how the finality requirement might play in. I mean, the court's opinion does not purport to change. In fact, it embraces the fact that you still need final agency action to cause the injury. I think this goes a little bit to the intersection with Loper, but you ask in discrete context, agencies have taken a position on when their work constitutes a final agency action. For an entity, say, that was not around when the rule was promulgated and might claim an injury from some agency action, like, I think our friend John Elwood mentioned recently in a recent post, something like a complete response letter or a warning letter. Agencies have taken the position that's not final. There may be an avenue after Loper to say, well, we contest your view whether that's final or not. How do you see sort of the finality issue maybe levering into some of this on either side with, bringing these challenges, what the scope is, even if it's not a substantive procedural issue? Welcome thoughts maybe that others have on that as a potential scoping factor on how these litigations might go.
I'm happy to weigh in on the procedural issue that you had asked just a few moments ago, Elizabeth, if that makes sense. Sure. And I would just point everybody, there's a footnote, and I think this is what you were referring to, in Corner Post itself. It's footnote 8 of the majority opinion. I think this issue it's a very interesting issue, and it's not about the statute of limitations as such, but rather about the nature of procedural APA claims generally, and who has an interest in enforcing procedural APA claims. So what the court says there, it offers the possibility that there may be some injuries that can only be suffered by entities that existed at the time of the challenged action. And it doesn't embrace that. It's just saying this is possible. And it says that, look, only parties that existed during the rulemaking process maybe can claim to have been injured by a procedural shortcoming, like a deficient notice of proposed rulemaking. So you put out a notice of proposed rulemaking that maybe does not actually flag the issues that are going to be addressed in the rule, and the party doesn't exist at that time. Have they been injured by that deficient notice? And the way in which you can just conceptualize, it says nothing to do with statute of limitations. Let's say hypothetically, we're dealing with a party that doesn't exist at the time the notice comes out, but is incorporated like days later, or, you know, I don't know, months, years later, just a year later or something, but within the statute of limitations. And then can that party claim that they were injured by the deficient notice, even though they didn't exist at that time? They otherwise might be able to bring, you know, it's not the statute of limitations that's stopping them. It's the fact that we're conceptualizing procedural violations of the APA as having a certain type of, creating a certain type of injury only by the people who are there at that time. And well, look, if the court were to embrace that, that would be a very important holding for just the APA generally. And all I can say is that the court in the footnote 8, flags the issue and brackets it. It doesn't embrace it entirely. So I welcome anyone else's thoughts.
I will say one way to characterize that is an issue of standing. Both, you can think of it as constitutional standing, and then of course, you know, statutory standing, or whether you have a cause of action under the APA. I think if you had to choose a bucket, the litigant would try to say, as Allison said, I'm injured by the rule, not, you know, that's my problem. I'm injured by the rule. I'm challenging the rule, and you know, the challenge I'm bringing is that it wasn't adequately noticed, or there wasn't an adequate comment period. That would be the challenge. I think the government might very well look at the causation prong of standing analysis and say, well, you know, you really have to think about what your challenge is and how that affects your injury. So that might be
redressability in a way, right?
Well, it might be, it obviously would be redressable, but I think it might be a causation type thing. Like if you think of like old tort law, right? Like, you know, that sort of sounds like you might think at some point it's too far back in the chain of causation. I think that might get litigated in the future. And that's just a procedural error. You could think of some errors that you might think that the court would be especially solicitous of. The court has long said, if, for example, a governmental panel, like a judicial panel, is somehow unconstitutionally constituted because of, let's say, a failure with the appointments clause or something like that, then maybe that is something that they tend to have very, very generous standing analysis to allow people to challenge. You might think that kind of challenge would be allowed, but maybe not sort of a mistake in some of the sort of more detailed fast.
I think the distinction between procedural and substantive challenges might well be made by the court in the future, but I don't really understand how it connects to standing. I mean, it can't be the rule that you have to be in existence at the time the notice is issued to have standing, as Aditya was hinting. And if a defective notice of rulemaking is issued, you can't sue then. I mean, there would be no final agency action.
Right.
You would have to wait until the rule is issued, and you'd have to be injured by that rule to have standing to sue at all.
Well, and that was my question about the letters and things. I mean, when you think about maybe the way, you know, John was also putting it, the chain of causation, it's like, okay, you have the notice, there may be a defect, but then you have to have the final rule. Then you have to have somebody who's injured. The agency may take the view that that's not even a ripe issue because they've issued a letter or a warning, or you're in the process of something. You think you're injured. They say it's not final. You know, so there's a causation issue, I think, that has to be litigated. I also think there's sort of a remedies issue, which I did want to get to at some point, which is, you know, and the court, I think, also expressly reserved this. And there's some, you know, language that in the opinion that sort of seems to assume without deciding that vacator is an appropriate remedy. I think there's room, certainly, I'd like to hear people's views on this, but I think there's certainly room to litigate that issue on a continuing basis, and also in what circumstances that would be an appropriate remedy. So welcome thoughts on that, to the extent that people want to continue kind of following the thread of unless and until Congress acts and makes some changes. For those of you who may be involved on that side of it, what do we do in the interim?
I think all our answers to your question about this procedural thing, which involves remedy, standing, finality, calls of action, just shows that the result of the courts, reflecting my own views now, anti regulatory project over the past few years has just been to sort of raise a lot more questions and create some chaos, but also to expose that it just would be nice to have really a wholesale reconsideration of the best way to handle administrative law litigation, because right now what we have is so many questions, potential challenges of rules going back 40 years. You know, an agency does something, it can be challenged 5 times tomorrow and then 10 times a few years from now. What is the scope of the remedy? You can argue those things either way, as the justices have. How long this statute of limitations should be. Congress usually has chosen, I think the longest one I found where Congress had a specific statute of limitations to challenge agency action was 120 days. By far the most of them are 60. Occasionally there's a 30 or 90. So as Congress considers a bill to address corner post, I'd like it to actually give serious thought to what the right limitations period is, rather than just codifying expressly a 6-year limitations period that, you know, as we've explained, was just sort of chosen by, there was never a conscious decision that 6 years was right, but it's what we have. So what should the statute of limitations be, and should it also be a statute of repose? And if we are going to have unlimited challenges for an infinite amount of time, is vacatur necessary? Is that actually the best remedy, or is it not? And who should be able to bring a procedural challenge and who shouldn't? If we were in a different sort of political environment, I think it would be really beneficial to everyone, regardless of their views about agency practice and regulation. Just if it were possible to have a conversation about just like what is the best way, what are the best answers to these questions, so that the system is workable.
Could I jump in on that? So I think an important part of the issues that Allison is raising is something that John Duffy mentioned, and that Justice Kavanaugh talks a lot about in his concurring opinion, which is the distinction between challenges by regulated parties and challenges by parties who are not regulated by the regulation in question. So, you know, if we change to a system, some people thought we had this system until this decision, but if we changed following this decision to a system in which challenges to a regulation have to be brought within a specified time period starting from the issuance of the regulation, it would still be true, unless we're going to change this, that challenges can be brought in the context of enforcement proceedings. But that's only helpful if you're regulated by the matter in question, if you're one of the regulated parties. If you're a party like Corner Post in this case, or like environmental plaintiffs in other cases, where you're a beneficiary of the regulation and you want to claim that the regulation is not strict enough. I mean, the regulated parties would usually claim that it's too strict. If you want to claim that it's not strict enough, you can't wait to do that in an enforcement proceeding, because you'll never be the subject of an enforcement proceeding.
And then
So
what's the remedy? I don't know if you want to comment on that, but to me, the other question is, if you are someone who can bring the challenge later on an as-applied basis because you are injured, is the remedy just that we're seeing this play out in the labor space and other things now? I mean, is the remedy that the rule is just not enforceable as to you and you get relief, but otherwise it's enforced? Or does it negate the rule? I mean, require vacatur of the rule? That's an important question.
well, back when I litigated for the government, we always tried to say that in general, it was a principle of equitable relief that you only get the equitable relief you need. So if you're seeking an injunction, you should only get an injunction that's applicable as to you, unless you're in a situation where you can only get your injury remedied if the whole system is changed. So for example, if you bring a desegregation claim, if you say this school that I go to or this, metro system is segregated and I want it to be desegregated, there's no way for it to be desegregated just as to you. So that's something that can only be cured by a system-wide remedy.
And that goes right back to the promulgation point, though, does it not? I mean, I think that's the interesting question is, can a rule be, promulgated in violation of the APA just as to one person, or no, that's the rule, right? It either was or it wasn't.
Well, Justice Kavanaugh points out that in this specific context, the APA expressly says that the court may set aside the action in question, which does suggest that if the action in question is the promulgation of a rule, the rule can be set aside.
Right.
There are also other agency review statutes that I know that the government disagrees about the meaning of set aside, but there are other agency review statutes that are more clear that, well, not that I think set aside is unclear, but that say things like modify, reverse, that make very clear that what the court can do is dispose of the rule entirely and not just as to the party.
I'd like to say that for people who deal with administrative law all the time, there's another way of thinking about what both these cases. Allison said it's anti-regulatory. I think it's a little different. This is really the triumph of textualism. These are both cases that were predictable, both Loper-Bright and Corner Post. Loper-Bright is a case where the court expressly relied on the first sentence of Section 706 as the basis or a major component of the basis of its holding. That section was not mentioned or even cited by any party or amicus in the Chevron cases, because that's just not how law was done back in those days. It just didn't so much matter what the APA said. And so too with Corner Post. 2401, if you look up the term accrual, it actually does have a pretty defined meaning, despite Justice Jackson's dissent. And you really have to work hard on the contextualism to get even a decent argument. But the courts, when this statute of limitations was borrowed and then interpreted to be a different, a statute of repose, they just didn't care so much about the text of the statute. They really looked at the policy and developed rules about this as a matter of common law. These sort of administrative common law features have been eroding now for 2 decades, and both are predictable. And I think people more generally who are involved in administrative law should, when they're dealing with a doctrine and they think, oh, this is very clear doctrine, that this Court of Appeals said it, that Court of Appeals said it, or even the Supreme Court said it, they should really think twice and think about, gee, what's the underlying statutory basis for this doctrine? If the answer comes back, courts never identified a statutory basis, or they have identified a statutory basis like 2401, but they really haven't, tried to define what does accrual mean and how do I turn that into a statute of repose. You should really think that there's an issue there, an issue that might very well be worth litigating. And I do think Allison's also right. And that's the last thing I'll say is that the court in the Loper-Bright case said all the cases are protected by stare decisis. But I must say that's kind of keeping the promise to the ear, but breaking it to the hope, because this is going to, a very few set of cases get to the Supreme Court on Chevron. And in fact, in the last 20 years, there's been very few that the court has, certainly in the last 10 years, very few cases where they've actually deployed Chevron in the government's favor. So a lot of Chevron cases are in the Court of Appeals. The government might have won in the Fourth Circuit, the Sixth Circuit, but there's a lot of other circuits to try your luck. And this potentially gives you the opening to try your luck in a different circuit. And then that circuit, I think, can say, well, this other circuit upheld the regulation under Chevron, but we're not bound by that decision under stare decisis. And in fact, we're now bound by Loper-Bright, which says we don't give deference. We have to follow Section 706(1), and we have to decide the issue, meaning decide de novo the issue of law. So I think the combination of these two decisions could lead to a lot of new challenges. But I think that that's an aspect of just, sort of a intentional or unintentional triumph of textualism.
We've got about, I think, 5 or so minutes before maybe we can take some questions, if I'm not mistaken. I guess walking away from this.
Elizabeth,
Yeah.
oh, I'm sorry, I didn't mean to cut you off, but I
No,
thought
please.
maybe, if I could weigh in on the enforcement action and
Sure.
the injunction point, the universal injunction point. On enforcement actions, I think John Siegel is entirely right, which is that even before Corner Post was decided, there was a way to challenge regulations outside of the statute of limitations. You could just stand back, wait and see if the statute was being enforced against you, and then say, oh, the regulation's invalid. And unless there was a specific provision, like arguably the Hobbs Act or some of these other provisions that cut off challenges at the regulation enforcement stage, unless there was that type of provision, that was perfectly permissible to challenge a regulation at the enforcement stage. So what Corner Post gives is this other avenue, an additional avenue to challenge regulations. And we'll see if that's noticeably changes, how the regulatory framework works. Because people could have just stood back, waited for the regulation to be enforced, and challenged them at that point. And then John Siegel, again, he highlighted Justice Kavanaugh's concurrence about universal injunctions, and I think a very interesting concurrence on that point. But there's so many ways in which universal injunctions intersect with the statute of limitations. And I think a simple way would be, let's say there are some plaintiffs who can challenge a particular regulation because their APA injury arises later, and so they're within the accrual period. Others cannot because of some earlier arising injury. They're outside of the accrual period. Can the plaintiff who's within the statute of limitations obtain nationwide relief on behalf of those whose claims are time barred? It seems a little bit awkward that they would be able to, but I think that's something that maybe courts would be confronting at some point in the near future.
Thank you. I was going to say, I think that was a good wrap up. I mean, what I heard coming out of this discussion, just to recap, and then I don't know if folks have questions, is just, coming out of this decision, unless and until Congress acts, there's some interesting questions. Anyone on either side of one of these matters should look first also at the organic statutes, make sure that, you're within or without the Corner Post framework. That's an important question up front. Folks have mentioned the Hobbs Act. There may be other things. Look at the nature of the plaintiff. Who is it? Where were they when the rule was promulgated? What's the nature of their injury? Finality is still a thing. It's still a requirement. If there's issues to litigate around finality that may intersect with things like, Loper Bright and Chevron deference, that's something to be mindful of as we go forward. And then the issue is, after we get through that slate of issues, what sort of relief are we seeking and why? And how does it intersect with some of this history and precedent? And then, whatever your position may be, obviously this is percolating in Congress. I think the Congressional Research Service issued a report about 2 weeks ago. You can track some of this legislation online, and obviously ACUS has projects going. So this conversation is just, I think, one of many that's going to continue. So I think those are some great points we touched on. I don't know if there are questions from folks in the audience or if our panelists have additional comments or thoughts to offer. I will stop and open it up. I don't know if there's a way for me. I can see the Q&A. Let me
If
see.
you click on Q&A, there
Got
are questions in the queue already. The first one is how res judicata intersects with this. I mean, my thought on that is that res judicata is party-based. So if the same plaintiff were to try again, they would be barred by res judicata, but that wouldn't apply here where there's a different plaintiff.
Yep. I don't know. Can everyone see these questions? The next one up is if a procedural harm is not just a reflection of the substantive harm from the final agency action, how can an entity that was not around when the rule was promulgated be harmed by a failure to provide a procedural protection of which they could not take advantage at the time?
Well, I think the answer to that question is they would at least say, look, I'm not claiming to be harmed by the procedural violation. I'm claiming to be harmed by the rule. And then that's how I think you get into this question of perhaps, how to think about what the procedural harm is, and causation might be one way to sort of analyze that problem. Or it might just be that this is all just a red herring and there isn't going to be such a new procedural limitation on things.
Yeah, I think that goes to whether it's a standing issue, I think, or more whether if do you have to have injury for each argument you make, or just have injury to support a challenge to the rule. It doesn't feel logically like you should be able to make a notice and comment objection, 10, 20 years later. But on the other hand, if the rule didn't injure you until 20 years later, and there's no statute of limitations or effectively, then maybe that did injure you, and that it led to the promulgation of a rule that, according to the plaintiff, would not have otherwise been issued. A court might deal with that in different ways. It might come up with some sort of standing thing. It might just say some sort of laches equitable type thing. I don't think that's where most of the challenges that we'll see, though. I imagine most of the challenges that Corner Post will presumably unleash will be more about challenging agency action as arbitrary and capricious or inconsistent
Contrary to law.
with statute.
Right.
And
But that's-
Corner Post itself had both, I think.
Yeah.
There was a little bit of a debate in oral argument that about they said all our challenges are substantive, and the government said, well, wait, they've got arbitrary and capricious claims. Aren't those procedural? Now, I think those are probably substantive, but perhaps there could be a debate about that. There's also not just constitutional standing, there's also statutory or cause of action, whether they're adversely affected or aggrieved within the meaning of a relevant statute. That might be another way for parties to litigate that issue.
I was just going to mention the argument too. Yeah. Next question in the chat is sort of the other side. It's if a party is saying that the regulation is not strict enough, I guess kind of a la Corner Post, why wouldn't the proper way to remedy that be to ask, this is sort of a separation of powers question, ask for a new rule or lobby Congress? I mean, why should the courts be in this at all?
Well,
Go ahead.
I mean, I think the answer to that is that the party is claiming that the rule is illegal under the statute already passed by Congress. So, I mean, in this case, what happened was the statute says interchange fees should be reasonable in light of the cost of processing a debit card transaction. And the plaintiffs were saying the agency considered costs that aren't really costs that shouldn't have been considered. So they said, this is illegal under the standard already promulgated by Congress. Why should we have to go back to Congress? Should they pass a statute saying, and we really meant what we said in the first statute?
And another answer is to just say those two avenues of lobbying Congress and petitioning for new rulemaking, those are potential remedies. This doesn't foreclose them, but this opens up another potential remedy. And as far as Americans loving to go into the courts, well, that's a very, very long tradition ever since, democracy in America. That's where we go lots of times.
All right. And that's the thing. If the rule's final, the agency decided that's the rule and you think it violates the statute, the place to go is a court. Next.
I just add that Corner Post was also, and I think primarily, arguing that the rule was arbitrary and capricious, which really turns on the rulemaking documents, although they cited some information that was after the rule was final. But one of the hazards of bringing these challenges so long after the fact is that the rule might have been arbitrary and capricious at the time, but turned out to be a good, makes sense, or vice versa. But the court has to decide it based on the rulemaking record, the administrative record that is 10 or 15 or 20 years old. I mean, in Corner Post now, they're going to go back and, assuming the government doesn't have some sort of equitable defense to going forward, the rulemaking record's like 14 years old, and that's going to be a big part of what the case turns on. Which is why the question, which suggests maybe you should ask the agency, submit a citizen petition, put in new information, like that is one reason why that option might make more sense as rather than bringing what might be a sort of a stale case.
Allison, I don't know if you were the one who mentioned Brand X. The next question in the chat is that the court perhaps seems eager to overturn Brand X. And the question is, what happens in the interim if Brand X is overturned formally? Should we expect many more circuit splits or universal vacator?
Well, I have a quick reaction to that. Isn't Brand X already overturned? I mean, once you overturn Chevron, I mean, like Brand X is a Chevron case. I mean, I can't imagine teaching Brand X in my administrative law class, given that I'm not going to, that people are literally debating right now whether you should even teach Chevron because it's not good law anymore. Brand X is a Chevron case, a kind of nuance to Chevron. It's sort of, you take out the whole foundation, that's gone too.
The next question, Aditya, I think is expressly addressed to you. I don't know if you can see these.
Oh, I do see it. And so just for the benefit of everybody who might be listening to this as a recording, I agree, by the way, with what the question is saying. So I agree with where the question is going. But the question says, isn't the difference between challenging the regulation as final agency action in an APA claim and the application of that regulation in an enforcement proceeding, isn't there a difference? Because in the case of the latter, the court could not set aside the regulation if the challenge is to the within the enforcement proceeding. In other words, wouldn't the scope of relief be much more limited? And that's certainly correct. In this, I agree in that in the enforcement proceeding, the relief you get is the enforcement proceeding is arguably, if you're successful, dismissed. And so that's the relief you get. Whereas arguably, and the reason I say arguably is because there's this debate about vacatur under the Administrative Procedure Act that we can't get into all the ins and outs of, but arguably you get this broader relief if in fact you're bringing the APA claim. So I agree with this question.
Anyone else have comments on that, or?
Well, I will say that, if the agency keeps losing its enforcement actions, at some point the agency has to think about, gee, do we really have a rule anymore? And there's other scholarship about that, about inter and intra circuit non-acquiescence. If you search for that in law, you'll find a whole bunch of literature that was earlier terms to describe the same phenomenon. But at some point, if the agency can't enforce its law in a majority of the circuits, then it's got to really think hard about, they could say the rule is there. They may not be enjoined to enforcing it, but they can't make it stick.
And that's the other thing, I guess, is grounds for relief, like we talked about before. I mean, if an individual who has standing by virtue of being the object of an enforcement action brings a successful challenge and finds something like a defect in the promulgation of the rule, that may well, including under the language of the statute, the set aside language or otherwise, open the door to broader relief. And there's just that case. That's obviously something that people are talking about. The next question is kind of, I guess, back to this old, issue of whether there's I say old, an hour old, but we've been talking about it since the top, the procedural issue. The question is there anything left of the requirement to have participated in or submitted comments in the rulemaking proceeding? I assume they mean as a predicate for challenging the rule or for standing, but that's not explicit in the question.
I don't think that's the requirement. I think the requirement is that the issue have been raised in the rulemaking proceeding, but someone challenging a regulation can raise any point that you can find in the record, whether or not they submitted a comment on that point.
Yeah, I've always thought of it as an exhaustion thing where just, the agency has to have had some chance to consider it. But
it's like a global exhaustion.
Right, global exhaustion, like you had a chance to look at this and then you messed it up for whatever reason,
Someone made you look at it, didn't have to be me.
Right.
I will say this is another doctrine that people should be wary of. The APA itself does not have a global exhaustion requirement. That's very much a case law development. So the more you think that the court is adhering very carefully to the structure of the APA, the more you might think that, but the lower courts and some circuit courts say you have to exhaust administrative remedies and thus in such a circumstance. And that's just not grounded in the APA. Nobody's ever tried to tie it to a particular position. particular section of the APA, that is, I think, wobbly at this point.
Well, and it's interesting you say that because in my experience, and this is just kind of ad hoc, that's been in some respects, at least in my experience, litigating kind of an adjunct or sort of adjacent to the Chevron issue, right? And there's been some question of like, well, if we're deferring to the agency, there's nothing to defer to if something wasn't raised and they didn't even consider it. So there was kind of, some intersection there, what that looks like and means, after Loper Bright and how we're going to, handle these cases going forward on what some might have called sort of a cleaner slate is, I think, a good question and, relates in part to what you just said. I think these issues, the next question is kind of a piece, I guess. The next question is, are there any limits on what a defendant in an enforcement action can raise? The contemplation here is notice issues. And if so, why should Corner Post be in a better position?
Well, the case that comes to mind when I hear that question is the Nova Scotia Food Products case, which is in a lot of administrative law casebooks. And in that case, the agency promulgated a regulation requiring that smoked fish be smoked for a certain amount of time at a certain temperature. And whitefish processors said, this is crazy. They sent in a comment saying, that may work for other fish, but it will totally destroy whitefish. You're abolishing the smoked whitefish industry with that regulation. And they went ahead and promulgated it anyway. And then they tried to enforce it against Nova Scotia, and Nova Scotia said that, this was crazy. And the holding of the court was the agency didn't adequately respond to that comment. The court didn't say this regulation is impossibly crazy. They might have said that, but the actual holding was you didn't sufficiently respond to that comment. And so, I would call that a procedural issue that the defendant there was allowed to raise in the context of an enforcement proceeding. So it's not clear to me that Corner Post is really asking for more than defendants in enforcement proceedings have.
And in those, when that's the issue in an APA case, is a affirmative 706 case as opposed to an enforcement action, the remedy is usually vacatur without remand without vacatur, so that the rule remains in effect while the agency reconsiders to address the issue that it had overlooked, which is obviously not what Corner Post is looking for.
I don't know if the person who asked the question had this in mind, but what it made me think about is that lower courts, not the Supreme Court, but lower courts have made a procedural substance distinction in the context of statutes like the Hobbs Act, where for those of you who may not be familiar, the Hobbs Act is, and I have to use the word arguably again, it's arguably one of those statutes that that cuts off the ability to litigate the validity of a regulation at the enforcement stage. And I say arguably because there was a case a few years ago called PDR Network, in which a number of justices, but not a majority, said that that's not how they read the Hobbs Act. They don't read it to cut off litigating the validity of a regulation at the enforcement stage. So as a matter of statutory interpretation, they read that differently. But there are other statutes less famous that have been held to cut off enforcement have been held to cut off litigation of validity of a regulation at the enforcement stage. There are some other agency-specific statutes. And under statutes like the Hobbs Act, lower courts, and the name of the case is escaping me from the DC Circuit, but lower courts have said, some distinctions can be made between procedural challenges and substantive challenges. Some of those challenges you can bring in an enforcement action, and some of them you can't bring. And my recollection when I looked at the cases, and this would have been some time ago, is that they're a little bit atextual. They don't necessarily grapple with the actual language of the Hobbs Act, but they may be a natural, sort of like sensible way to approach the issue. So maybe that's what the person who's asking the question was thinking about, is that there is this procedure substance distinction drawn in the context of the enforcement stage with respect to these other types of statutes like the Hobbs Act, And I suppose corner post in that footnote 8, raises the possibility that there could be a procedure substance distinction drawn even outside of that context, because we might think of people who weren't there in some sense as not having a procedural right.
Thank you. One thing, I want to be mindful and respectful of everyone's time. It's 1:15. We've got 3 questions left on the board. I don't know if we're 4, so I don't know if we have a couple of minutes. I'm happy to run through them, or at least the one of them, which is kind of an interesting one. I'm not sure I'm reading it correctly, but the question is, you know, in the corner post context, could you have bank-related parties bringing counterclaims against corner post that the rate is in fact reasonable or too low? I'm not sure if the question means counterclaims against corner post the party or against the rule, you know, sort of taking the other side of it, which is maybe the way to think of it. I don't know if anyone has.
I don't think they can bring counterclaims. They could file an amicus brief, or if they think that the Fed isn't doing a good job, they could seek to intervene. But they wouldn't have a basis for a counterclaim against corner post. As long as corner post is paying the fee, they have no standing to challenge anything corner post is doing, and corner post lawsuit is not causing them injury.
I think that's right. No counterclaim, but they could sue the Board of Governors, just
Right.
like Corner Post did, and say, "Oh, by the way, it's not too high, it's too low." It would have to be a new bank.
Yeah.
So you'd have to find a bank that didn't exist, you know, was incorporated or regulated in this way in the last 6 years, or you'd have to have them just start charging higher rates in some way, and then wait till the board tried to
If
enforce
you
it.
wanted to argue that the as a bank that the rate should be changed, you would have to do that in a lawsuit based on the rulemaking record from 14 years ago.
That's
Otherwise,
right.
yeah.
That's right. Or you could also file a petition for a new
Citizen
rulemaking. Right. Yeah.
Maybe one more. We've got a question about this. I think we touched on when we talked about res judicata, but there's a question about why couldn't the government just rely subsequently on defensive collateral estoppel if it previously received a favorable ruling? And I think the, you know, non-mutual issues and other things are probably the answer there, but I welcome comments from the panel.
Yeah,
Well-
I don't think collateral estoppel would be available. John's the Civ Pro professor. I'll let him take it from there.
Yeah, if the non-mutuality rule says that a defendant who's already litigated an issue can be bound even if a different party is asserting the estoppel. But if a new plaintiff is challenging the rule, you can't say, oh, we won this in another case. You know, if someone sues and says your patent is invalid, you can't say, oh, in another case, somebody brought that up and we won. It was declared that our patent was not invalid. You know, the who says, well, I wasn't part of that case, isn't bound by it.
You can cite it as persuasive precedent.
Oh,
but
sure. Yeah. The stare decisis might apply, but not issue preclusion.
There's a case that comes to mind on this. It's called Taylor versus Sturgill, and it's from, I want to say, around 2008, and it arises in the FOIA context. So somebody claims against the United States government to they want under FOIA to obtain certain documents. They lose, and then somebody else is bringing a pretty similar claim, and the court says that res judicata doesn't apply in that context.
Argued by my colleague Adina.
Well, I think that's it for our slate of questions. I hope it was helpful to those listening that we were able to get to, I think, all or most questions that we had in the board. Any final comments from any of our panelists before we close? It's been such a pleasure having everyone here today and being part of this.